Our final invited speaker in relation to those legal issues, and who's going to, I think, develop what might be one of the most interesting aspects of the discussion tonight, is Lutz Oette. To make sure I've got my profile right, but Lutz is extremely experienced. He is a lecturer in law at SOAS in London, and prior to joining the organisation Redress, he has worked with several human rights organisations and research institutions in Germany and the UK. And I'm particularly glad we have Lutz Oette with us this evening, because one of the topics I'm interested in, and I'm sure many of you will also be interested in, is the prospect of having international law pressure and international law activity brought to bear on the situation in Sri Lanka as it is at the moment. So I'll hand over to Lutz, and maybe you could deal with those issues. I'm afraid we are quite short of time, but I'll give you as long as I possibly can.
All right, thank you very much for that. Yes, what I would like to do is really to examine what international legal avenues are available to hold perpetrators of serious human rights violations and international crimes accountable, and to obtain a measure of justice and reparation for the victims of such violations. And before I go into the details with regards to the available avenues, I think it's important to remind ourselves that the recent events have to be located in a much broader framework of a legacy of violations that spans almost 4 decades by now. If you take the 1971 JVP insurrection and the crackdown as a possible starting point, I think there are many one can look at. You have the 1983 pogroms against the Tamils, up to the recent events when the conflict finally ended. So there is a history of serious violations, both in a conflict context, but also systemic violations, if you like, when it comes to the work of the law enforcement agencies. And what is important here is that we have a large number of both perpetrators and victims, which makes it incredibly difficult really to obtain justice and reparation in respect of all the violations we are talking about. And I think what is also important not to forget is that it is not only the Tamil community that has suffered from such violations. So again, you find members of both communities on both sides of the perpetrators and victims. That by no means means that I want to belittle that the Tamils have suffered the brunt of violations, and the government is arguably bears the greatest responsibility for violations over the years. But I think it's just important to be aware of the complexity of the issues. I know tonight we are talking about the more recent violations, and I think it's understandable to focus on these, and for very practical reasons I agree with such an approach. But I think the quest for justice runs much deeper, and any efforts to obtain justice and accountability should be mindful of this legacy of violations. And closely related to this legacy, and if you like, inextricably linked with it, is a pervasive culture of impunity. That has already been touched upon by previous speakers. And I think the situation has been well documented over the years, especially the breakdown of the rule of law by organizations such as the Asian Human Rights Commission. But just to restate what the situation really is, we've had a number of inquiries into violations. Many of them were either not impartial or not effective, or were not allowed to to actually complete their work. Then we had a number of high-profile cases, but only few of them actually resulted in convictions. And there have been a series of Supreme Court fundamental rights cases, but even these cases have not been, by and large, followed up by investigations and prosecutions of those responsible. So I think that is the baseline of impunity, with a few exceptions that we need to take as a starting point. And there are valuable efforts in Sri Lanka itself towards re-establishing the rule of law and towards holding individuals accountable. But I think it's against this background pertinent to look at the avenues that are available at the international level as an alternative to the domestic system that fails to provide an adequate measure of justice. So this is then the challenge for the victims and their lawyers, and also others who want to bring about a change, is how to use existing avenues, be it at the UN level or in other countries. And I won't really look into the current efforts to establish an international commission of inquiry. Yolanda has already mentioned that, and obviously that is a very important effort, and hopefully that will come to fruition. But I think that is basically a political effort at this stage. And what I want to focus on is really the legal avenues that individuals can use in the current situation. First one of these is the UN Human Rights Committee. That is often overlooked in the debate, mainly because I would think it is not a criminal body of sorts. Basically, it is a quasi-judicial UN monitoring body that examines the state parties' compliance with the International Covenant on Civil and Political Rights, and that's the most important treaty arguably binding on Sri Lanka, which sets out a series of obligations, including providing remedies to victims and investigating and prosecuting those responsible for serious violations. And the UN Human Rights Committee can then make findings in individual cases stating that the state has violated its obligations and provide for measures of redress. So in the case of Sri Lanka, there have been, according to my latest information, there have been 15 cases, 12 of which have been successful, which involved a number of serious violations. But one of the problems is that the UN Human Rights Committee itself doesn't have an enforcement mechanism. So it really goes back to the country level, so that the lawyers and the victims will have to seek to enforce decisions in Sri Lanka itself. And that has been tried in such cases as the Singharasa case, where someone had been, Singharasa, had been convicted under the Prevention of Terrorism Act and on the basis of confessions extracted under torture. And the UN Human Rights Committee held that to be unlawful, but the Supreme Court stated that this decision has no binding legal force on Sri Lanka. So there is a measure of disenchantment on the parts of lawyers with the lack of effectiveness of the UN Human Rights Committee, and a lot of the lawyers also face the difficulty of the lack of victims and witness protection, which makes it very difficult to pursue cases both in Sri Lanka and abroad because of the feared repercussions. But I still think that the UN Human Rights Committee can provide for a very valuable record of violations and hold the state responsible.